Hi, and welcome to Cloudigy Law's Everyday IP live stream show. We are doing these shows so that we can talk about issues in intellectual property and technology that are making headlines. We try to talk about them in plain English and give you a sense of how they might affect your life and your business. We really want to help you grow and protect your content and creations. So today I am joined by my colleague, Amanda Herbert, and we are going to talk about one of our perennially favorite, topics, the Digital Millennium Copyright Act, or the DMCA. The DMCA has been in the news a lot over the past year or two. It seems to always make headlines in the pop culture context. But recently it's been in the headlines because the Copyright Office, which is headquartered in the Library of Congress, has issued some new rules related to service providers. But I think what makes sense first, Amanda, is to talk a little bit about the DMCA and what it is. So can you kind of give us the spiel on that?
Sure. The DMCA is basically an act that was enacted to usher the copyright world into the 21st century. It does a lot of things. Some of the things it does is to respond to various treaty obligations the United States had in the international realm. It also does things to keep people from circumventing copyright protections on technology and software. But for our purposes today, we are really concerned with Section 512, which deals with giving a safe harbor to service providers, assuming they follow certain procedures, and giving people who have content that's being infringed on the internet an easy and extrajudicial way to take it down.
And it really made sense, when Congress was talking about the DMCA and trying to usher copyright into this digital age, it became really clear, and we talk about this a lot, that infringement happens very quickly and it is disseminated far and wide a lot easier now than it was even 10 years ago, much less 15, 20, 30, 40, 50 years ago, or in the 70s when there was no internet, right? So, the idea was to bring copyright law kind of into the computer age, right? And into the internet age. And at the same time, to really try to balance the interests of content creators and people who were doing things on the internet, right? And one of those key things was to protect service providers who were essentially providing access to the internet and allowing people to put content up there, but weren't really controlling the content, right? And so the idea was, okay, if you act as a good citizen, we aren't going to hold you liable for infringement, even though in a traditional copyright analysis you would be, right?
Exactly.
But of course, this isn't a free pass. And, you have to do some things to kind of protect yourself, right? And so this has come up, one of the more interesting cases we looked at in the last year, that's actually been going on for, I think, 6 years now or
Still going on.
Still going on, right? Cert petition before the Supreme Court. Is the Lens case. Now, you guys, if you have listened to our podcast at all, you'll know that we call this Prince's Dancing Baby. This was a case where a mom had a video of her kid dancing around, and the music in the background was "Let's Go Crazy" by Prince, our dear departed Prince. And she put it up on YouTube to share it. It was a funny video.
Everyone loves videos of dancing babies, right?
Exactly. The internet was made for videos of dancing babies and other such things, puppies and kittens. But the catalog that owns the license rights to Prince's music sent a DMCA takedown notice and got that content taken down, and there ensued a fight over whether that was appropriate or not, or whether that was infringing or not. But that leads us into talking about this as an example of the notice and takedown process in the DMCA. So how does that work, Amanda? What happens?
Basically, web service providers are required to give a designated agent to receive DMCA takedown notices to both the Copyright Office and also to provide it on their website. You can see YouTube's policy right here, where you can click through and reach the designated agent and send your notice to them. Once they receive a notice, they are required to take it down and also send a notice to the person who provided the content in the first place, the alleged infringer, saying, hey, we've taken down or we've disabled access to your content. And then that person has a chance to respond. That's called a counter notice. And if they do respond, the internet service provider has to send another notice to the initial sender of the DMCA notice saying, hey, we got a counter notice. You have 10 days to file a lawsuit. If you don't, then we're going to put it back up. And basically, because there's no oversight to this process, you have a lot of issues with abuse of the system, like with Ashley Madison, or actually with Len's case with the dancing baby.
Yeah. So this is, I always like to use this case as kind of an illustration of the process, right? Because here's what happens, and this is a technology issue too, right? So obviously the internet is a wild, woolly place, and you can't search the whole thing. So what particularly companies that have music rights or photography rights have created bots and other technologies that kind of scour the internet and find people who have posted things that appears to be unauthorized. And what a lot of these, particularly the big companies, were doing is sort of letting these bots search the internet and then just automatically sending takedown notices, right? So not really looking at
fair use.
Right. Not looking
lawful
at
uses of material.
whether or not this was infringement or not really, or whether there was a legitimate fair use going on or anything, right? And so, they send out these blanket notices under the DMCA to get content taken down. Now the providers, YouTube in this case, they are doing what they're supposed to do to stay within the safe harbor, right? So they say, oh, we got a notice. We're required when we get the notice to take it down and to let you know, right? And then we kind of step out and we let you guys battle it out. But at the end of the day, unless a lawsuit is filed, we get to put it back up, right? And what the DMCA basically says is, hey, if you follow these procedures, then whatever the ultimate decision on infringement is, you, YouTube, are not going to be liable, right? So the statute requires in order to get that protection, the statute requires several things, right? So we talked about the notice and takedown procedure. The statute also, and I think a lot of people aren't really aware of this, they require, we just had the list up a couple minutes ago, they require a termination policy. So if someone is infringing a lot, you are required to take their content down and kind of ban them, right? And say, look, you keep infringing, you can't be on here anymore. The other thing that the statute requires you to do is to to allow these bots, right, that these various companies have that scour the internet looking for infringing content. It requires you to allow that technology. So you're supposed to, let your site be searched. You're not supposed to block it in any way. Then you're supposed to have the notice and takedown procedures, the counter notice procedures, and you're supposed to designate an agent. And you can do that. We've shown you the way YouTube kind of has theirs set up. There's a whole page with lots of copyright options. You can find all sorts of information, and that's smart, right? So we know kind of what the requirements are for service providers, but what does it mean to be a service provider?
It means that you host a website that other people can post their own comments and stuff on. It could be a forum, it could be a blog with a comments section, anything where anyone else can add their information, their content to your website, where you're not exercising full control over it. You're a web service provider.
Right. And that, I think, is something that people haven't really come around to, that sort of once the statute was in place and courts started interpreting what it means to be a service provider, it's not just the ISP, like the things that we think of as ISPs.
It's not your web host, it's you.
It's both, right?
Yeah.
So it's both your web host and it's you. So, in that sense, this is for a critically important thing. If you, for your business, for your marketing, if you have a website that you host, and you allow people to put content on there, you allow a community to develop, you allow discussion, and a lot of people are doing this. It's a creation of an online community. You need to be sure that you're following the procedures
that are going to keep you safe.
Yes, that as a provider, you are going to be, ensuring that you don't get held liable if one of your users starts posting content that's infringing, right?
Exactly.
And so part of that is following all of those little requirements of the statute that we just talked about. And the Copyright Office, which monitors all of this stuff, has come out with some new rules. You are supposed to designate an agent not just on your website, but also to the Copyright Office. And in the past, it's been a good old paper filing.
Gotta love the Copyright Office, right?
They love their paper. But finally now, they have moved to an electronic system, but they also made some other changes.
Yeah.
And so can you tell us a little bit, Amanda, about those changes?
Yeah, of course. So in addition to everyone, including old users of the system who have already designated agents, everyone has to use the new system by the end of 2017. So you have till December 31st to designate your agent with the Copyright Office. That includes contact information, particularly an email address. Another thing that you have to do, in the past, you only had to designate your agent once, and that was a valid designation until either you removed the designation or replaced it with a new one. Now they're requiring you to renew your designation every 3 years. So it will expire automatically on the 3-year mark if you do not renew it. They're going to send out automated notices of the impending deadline to renew, but it's still ultimately your responsibility to do so. They've also restructured their fees. So before you had a specific fee structure for paying for your designated agent. This time they're saying that it's a flat $6 fee every time you designate or renew with an agent. And they've also made some interesting changes to who can actually serve as your designated agent.
Right. So I was going to ask you who's the agent, right? Is this like service of process? Do I need some service out there, or can it be who can it be?
Actually, it's become much broader. So it can, of course, be an individual, as it always has been. A particular named person, Joe Schmo at such and such address, that can be a designated agent. But now it can also be a specific position or title in some sort of organization or corporate structure. So say you don't know who is going to serve as your agent for the next 3 years. You can say, okay, we're going to give it to this title or this position within my business. So maybe we can call it, hey, head of copyright, DMCA takedown notices. Right. You can give them that position, and you can actually give that there as long as it has the valid email address, phone number, contact information.
And that makes sense from a corporate perspective. If you have turnover or if you're growing or whatever, and you just say, okay, look, whoever's serving as, the second vice president in the company is going to be the person who is the agent, whether that is the person who's sitting in that position now or a year or two down the road, it's someone else. We're always going to have it in this particular corporate structure. And, if you're going to have turnover or, you're going to restructure or whatever, as long as you have a title in there, and that kind of makes sense because I think what was happening with a lot of these designated agents is you put, Debbie from HR is going to be the person, and then Debbie from HR moves along, but your designated agent is still Debbie, and then there's no valid email address and people can't actually do a DMCA.
It's also great from the standpoint of the fee arrangement because every time you change it, you have to pay a new fee. Granted, it's not all that expensive, it's $6. But still, it's still annoying. Yeah. It's still something you don't really want to do that often, especially if you use an aliased email address that refers to the position and not an individual, something that you shouldn't have to do.
Yeah, absolutely. So what else?
So similarly to the specific position or title, you can also have an entire department designated as your agent.
Oh, interesting.
Yes. So you can do Department of Copyright Infringement.
Or your customer service department.
Exactly.
Right?
You can designate your customer service department if you want to. And again, that's great because it means if someone leaves, well, you've got the whole department backing it up, and you probably already have a department-wide alias to use for that.
Right.
And the fourth person who can now serve as your agent is you can have third-party entities or vendors. So corporate vendors, law firms, anyone like that can serve as your designated agent. They don't have to be tied to your company anymore.
Right. So you can say, all right, every DMCA notice goes directly to the law firm. We don't want to deal with it at all in-house. Or you can have it come in-house, or you can have it go, sort of anywhere you want. For whoever gets that, because they're going to have to be the people responsible for acting on it.
responsible for acting maybe within your individual relationship, but it's important to note that even if you use a third-party vendor or a law firm or something like that, you are still ultimately the one responsible for taking prompt action on any DMCA notices.
Right. So if you have a third party designated as the person to get the DMCA complaints and they're off on vacation for 2 weeks and you don't act on it, it's not their fault, it's yours under the law, and you could lose your safe harbor protection, basically.
Granted, you could always resue the person who was supposed to do it for you. But.
True, but that is a little bit messy. So this is important only to say that, hey, if you're out there, if you're running a business that has a website where people are posting content, if you haven't ever designated an agent before, please do it. If you have designated one on paper, you're going to have to re-up. I think the rule changes went into effect at the beginning of this month, but there's a grace period, right? I think it's like a year.
Yeah, you have until the end of December 2017.
Right. So you have a year. Shouldn't take that long, but you have a year to get your stuff together and get in order and designate your agent. But also, new rules on designated agents notwithstanding, and you can just go to the Copyright Office website and designate one. But new rules notwithstanding, you still have to do all of these other things, right? So check your site, make sure you have a link to your DMCA policy, to process for notice and takedown, to all of the things that we've been talking about, just to put yourself on the safe side. So now I think it also makes sense to talk about the flip side. So we've talked about you and your business as a provider who wants the protection of the safe harbor, but we should also talk about content creators and how you can use the DMCA, because that's the flip side of this, right? You might want the protection as a company, but as a creative out there creating content in the world, you might also want to use the DMCA to protect your own content. So just as you need to have these procedures, you need to make sure that you are following your content. And if you think someone's infringing, a DMCA notice is something that you can use to take the content down, right?
Yeah, it's actually a very fast, efficient process, which is why I get used to most, and even if it's not always technically used correctly.
Right.
So to use it correctly, you need to be a content creator, and you need to have some sort of copyright or copyrightable work. And if you think someone is infringing that and you have a good faith belief that they're infringing it, including, statutory exceptions like fair use, you have to think that they're actually infringing it in a way that they're not allowed to, then you can file your DMCA notice, and it's the fastest way to get it down. It will require some review if they fire a counter notice, either a lawsuit or something along those lines, but it's really the easiest way to stop the bleeding if you're in that position. And
that's really why it was created, right? Was to take the content down sort of as soon as possible and then kind of sort out the issues. And a lot of times, I will say in our practice, you send a DMCA notice, and many, many times, I would say more than half the time, the content gets removed and nothing ever happens, right? That's it. That's the end of the line. You don't get a counter notice. Sometimes you do get the counter notice, and then you have to go through the process and potentially litigate it. But it is a very easy and fast way to control your content if you feel like it's being infringed. The other way, of course, and we've talked about this before, is to rely on the terms of service. So in particular, if you're using a platform like Facebook or Twitter or YouTube that have very, very developed terms of use and terms of service policies, you can always go that route too. So in addition to doing a DMCA takedown notice, a formal takedown notice, you can also say, hey, Facebook, I've seen this thing. It violates your terms of service. It violates your terms of use. It can be taken down on that basis.
And a lot of times they're just as fast as a DMCA takedown.
Yeah.
So they go through their service providers and see, hey, you're violating the term of service.
Yeah, absolutely. So, and we'll continue. You talked a little bit about fair use and how you make the determination. And that's actually the issue. Back to the dancing baby and Prince, which all of life seems to come back to.
That and cat videos.
The Lens case is actually currently on a petition for certiorari before the United States Supreme Court, and that means that although the Ninth Circuit sided with the plaintiff and said, they really were required to determine whether they had a good faith belief that this was in fact infringement. The court then said, but that's subjective. So even if they were completely irrational, good faith belief is sort of this weird subjective standard. And
mostly they just said you can't ignore it entirely.
Right.
That's kind of what they came out with.
So the Lentz and her team of lawyers have asked the Supreme Court to really take a hard look at what good faith belief means, and to say, no, that there is actually some objective standard there, that you really do have to truly believe that this is infringement, and that, it can't be so obviously fair use. And so, and this is one of the reasons why sometimes the interim step of a terms of service notice before you do a formal DMCA notice might be the way you want to go. If you're a little unsure, if you want to have that conversation, you can kind of go that route and buy yourself some time.
Well, also, they're allowed to do things when they're evaluating their terms of service that they're not allowed to do when they evaluate a DMCA takedown notice. They're only allowed to look at a DMCA takedown notice to the extent that it complies with the statute for a takedown notice, aka does it have a signature? Does it have a good faith statement? Things like that. But when they're looking at their terms of service, they can say, hey, this is what's actually up. Does this violate any of our terms? And they can kind of have a conversation with you about it. So a lot of times if you're not sure about the law, that is the way to go.
Right. I think that's right. And also, the same is true for you on the provider side, right? So if you receive a DMCA takedown notice for someone because of content that a user has put on your site, you have to take it down, even if you think that the takedown notice is wrong. Right. Yeah. So if you get a DMCA notice that says, hey, you've got this site, people posted photos onto the site, that's my photo, it's copyrighted, you need to take it down. You have to just take it down. You're not really allowed to investigate and decide, no, I don't think it's infringing, or I'm going to take the side of the poster on my site. Nope. You just have to take it down. And that is part of the safe harbor, is they're trying to take you out of the decision-making process. So if you get a DMCA takedown notice, just take the content down, right?
Exactly.
And do what you're supposed to do. Give the party the opportunity to make a counter notice, but you take that content down. If you get a counter notice, then you got to wait, and within 10 days of that, you ought to be notified that there's a lawsuit going on. If you're not notified that there's a lawsuit getting on, you can put the
you have to put it up.
You can put the content back up on your site. So, again, sort of on both sides, right? Because we know that you out there listening to us, some of you are content creators, some of you are content hosts, and most of you are both, right? So you're going to be on either side of these issues probably throughout your time as a business. And as you grow in the internet age, you are going to come in contact with the DMCA. So what we want to make sure is that you, on the one hand, know how to protect your own content by using the DMCA to get things taken down, or by using the terms of service. And on the other hand, you know how to protect yourself by complying with the DMCA, by following these new rules for designating an agent, and by taking all of the steps that you need to take to keep yourself in compliance, so that you're not then on the wrong end of a copyright lawsuit.
Nobody wants that.
Yeah, no, absolutely not. And we will continue to watch the Lentz case. We're going to continue, obviously, we always watch what the Copyright Office is doing. They periodically will issue sort of new rules or new interpretations, just like
actually part of the act is that they're required to reevaluate every couple of years or so.
Yeah. So as they continue to reevaluate, and they've done a lot of reevaluation on the anti-circumvention.
Well, especially after Volkswagen.
Yes. So, and we've written about this too on our blog, and I'm sure we'll probably do a show on it eventually. But these little pieces of the DMCA, and it's as I was telling someone the other day, copyright is a creature of statute, right? So it was created in a certain time as a statute, and as times change and we think about how copyright applies to new things, there's a reason, right, that we have legislative action to try to bring us in. And then, it takes time to tinker with it, and the courts have to deal with it, and the, technology improves, and then you've got people commenting. And that's really why the Copyright Office sort of has this mandate to re-examine and to allow people to comment and say, hey, this is what's not working, right?
Well, after all, being part of being relevant in the 21st century is actually responding to the faster speed of information. So
that's right. So, we will continue to watch this. We'll continue to let you know. I am sure that we will do a live stream on the Lentz case if the Supreme Court indeed decides to take the case. That case, the Solicitor General will be giving, Solicitor General's office will be giving their opinion to the Supreme Court shortly about whether they think the case ought to be heard or not, and then the Supreme Court will decide. And that may have a great deal of impact on you as a provider. And on you as a content creator who might be sending DMCA notices in the future. So we definitely will keep an eye on that. In the meantime, thanks for joining us here on our live stream on Everyday IP. We love talking about this stuff. Amanda's first time on the live stream. She'll be back a lot, I think. She might be talking about some gaming things and some other kind of fun aspects of IP law as we go forward. In the meantime, you can follow us on Twitter at Cloudigy Law. You can find us on Facebook on Cloudigy Law, on cloudigylaw.com, on our website. Our Decoding IP blog talks a lot about the DMCA and all various aspects of it and things that are going on in the case law with the DMCA. If you have ideas and suggestions for topics, if there are issues that are going on in your business, or if you're seeing a story that's out in the news and you think, I wonder what that's all about, tweet at us or shoot us a suggestion, info@Cloudigy Law. We'd love to hear from you and cover things that are relevant to your business and to your life. Thanks for joining us, and we'll see you next week.